Be with you guys. Before we get going, any specific questions, anything you have questions on you want to ask about before I jump into what we're going to talk about? All right, I'm going to take that as a no, which is just fine. So, what I thought I would talk about today, last week, Jason talked about the new listing agreement. And I thought today we'd go through and talk about the new buyer broker agreement and answer any questions, things you guys have that way. And then also, just as a reminder, that Jason and I will be doing base camp on Wednesday next week at 11 o'clock. And we're going to kind of run through everything and make sure that everybody is ready to rock and roll, because as of that day, the commission will be removed from the utahrealestate.com website, so from the MLS. Yesterday, it was removed from the St. George, the Washington County, and then I believe that Iron County is like soon. I can't remember. I don't know. Maybe you know, Tracy, but I know it's happening in the next couple of days anyway, if it hasn't happened already. So St. George went into effect on July 30th. So as of next week, all the MLSs in the state will have removed the buyer compensation. So anyway, so what we will do is we're going to just jump into that. Let me get my screen share up here so that you can see the buyer broker. So what we have decided to do, at least in the interim, and we'll see if this just stays this way or if it changes a little bit over time. But as of right now, our plan is we are going to just use the UAR, this Utah Association of Realtors buyer broker agreement, and the exclusive right to sell listing agreement is the plan. And part of the reason for that is I went to a meeting this week where the UAR attorney was there, Craig Wagner. And one of the things that he mentioned at this training is that he feels like that there'll be some modifications to this form over the next few months as we get started on this change. And so Jason and I have talked about it. And also, I think we've mentioned before, but over time, this has become like ours. We had Matt and Rob that had changed and made a bunch of changes on ours. And then over time, they ended up being on the forums committee, and they helped to implement changes that have had this become really more like ours. So anyway, that's kind of our feeling as of right now. There may be some things that we want to adjust or add down the road, but as of right now, the plan is to use those. And I have uploaded those to Loop for them to go through and put in the fields where, it would put in the name of the buyer down here, leave a space for you to type in the agent, all that kind of stuff. So that has been uploaded to Loop. They have to go through and add those fields before it will be available. So I'm hoping it will be available by Wednesday, but if not, it'll be shortly after that. And in the meantime, if it's not, just continue to use ours, and you should be fine because there's no reference to the MLS on there. So anyway, so we're going to go through and talk about this form. I'm not going to go through every section because a lot of it is still exactly the same. But the one that I did upload to Loop will already have Century 21 Everest in, just like what you're seeing right here. They'll have the spot for you to put in your name as the authorized agent, obviously the buyer there. But so let's talk about the term of the agreement. So on this one, this term of the agreement is going to go through and talk about the duration of it. And so just remember, the reason they put in here this end date right here is because they said a lot of times what agents are doing is they're putting in today's date right there. And we've seen that a few times where agents have done that. And if you put today's date in there, you're in essence saying that this agreement ends at 5 o'clock today. So whatever you're having them sign, which in a minute, what we talk about might be what you want to have happen anyway. But so this is going to be the end date that you're going to put in there. So you're going to just put in, the duration of it. So instead of saying 3 months, 6 months, whatever, you're going to figure out what that date is and put that in there. This next section here, under these properties or locations. So on this, you're either going to select, and this is similar to what we already had on ours anyway, it's just rearranged a little bit differently. So on this one, you're either going to check the box saying that it is for properties that are located only within, and then you're going to list the county or counties that you are having this buyer broker agreement be associated with, or you could do for a specific property or properties. You'll notice, so you can do either. So you're going to check one or the other of these boxes and put in whichever one applies. So if it's the counties you're doing or county, you're going to do that. If you're putting in a property or properties address or addresses, you're going to put that in there. So now let me talk about that for a minute. So we've had some debate going on between the leadership in our company, trying to decide, are we going to use some type of a showing agreement? And Washington County has created one. The Utah Association of Realtors decided not to create one. And their reasoning for not creating one, and I actually am on board with this as an FYI, is that because of the fact that you can put in properties located only within here or a certain property address there, and as I mentioned earlier, you could actually put that this ends today. You could put in the ending date being tomorrow or next week. They just decided that really it's better to use this form and either do it, if the client's hesitant or whatever, do it for a shorter time frame or for only specific properties that you are showing them. So I'm not saying that we won't maybe at some point have some type of a showing or a touring agreement, but as of right now, we're feeling like we don't want to do that. And the reason for that being, the biggest thing that kind of pushed it over the edge, for me at least, was one of the things that UAR's attorney mentioned is that people have contacted their errors and omissions to find out about this showing agreement. And what they are being told by their errors and omissions companies is that the insurance company would not, if you use the showing agreement and you go out and show a property and then somebody ends up suing for some reason, that showing agreement is going to create a scenario where the E&O will just deny the claim. So you would be left having to pay that all on your own. Versus so for me, I almost feel like you would be better off not having an agreement signed at all if that lawsuit happens, because you got at least you have a chance of it getting covered by your errors and omissions insurance. But once that showing agreement is signed, until you got this buyer broker signed, so that gap, that space between there could put you at risk for some liability if something were to happen, because that showing agreement spells out you are not their agent, you are not acting as their agent, there's no fiduciary duties, which makes it to where the errors and omissions company could go, great, because of that, you are not acting as an agent. This errors and omissions is for when you're acting as a real estate agent. So anyway, hopefully that makes sense. But the other side of that for me too, that I would just say is the thing to keep in mind on this is if you have somebody wanting to go see a property and they're not willing to sign this, even if you just said, okay, this is going to be for today and the two properties that I'm showing you, and they're saying, no, I'm not going to sign that. To me, at least, that feels like a red flag of like, they're probably planning on using somebody else anyway. So you might want to just let them go work with whoever they were going to. Now, the flip side of that is I also do get the argument that, hey, you're kind of asking somebody to marry you before you even go on a date with them. So I totally get that. But to some extent, you're at least limiting this to, okay, it's if you buy this property that I'm going to go show you right now, you're going to make sure that I'm your agent and that I'm going to get paid on it. So anyway, so hopefully that makes sense, that I haven't beat that up too bad. Any questions on that before I go on to the next part of this?
What if they change their mind and they don't want to be in that specific county or, from originally planned? Do you have to just write an addendum or what?
Correct. Yep. If anything that was going to change, so yeah, let's say they had signed it for Salt Lake County, and then they said, "Oh, we actually want to start looking up in Davis County." Then, yep, you just do an addendum and include Davis County with it.
Can't you just put all right there and then it covers everything? You don't have to change it later.
Correct. Could do that as well.
Russ,
Yes.
the only other thing that the attorney, not the UAR one, but the attorney that's a realtor and an attorney that did the training in Washington County for a couple days said was so the difference between the two, obviously our buyer broker, you're acting as an agent. You have all those fiduciary duties. If the seller tells you something, it's as if your client knows. So if they only use you for one day and the client says 1, 2, 3 or whatever, if you don't relate that to the client and they do go and use someone else or the end of your contract, whatever, and it comes back that you never told them, you did. And so you're on the hook for it because the other agent didn't know and the seller is telling you that they told you. That's the only other thing she said. What do you feel about that?
So I guess I'm not sure let me make sure I fully understand. I guess you're saying if I sign this with a buyer for one day and then I somehow find out something from the seller, and I think that's where maybe I'm a little confused, is how am I,
Within
did
that
they
one
use it?
day of your
Yeah, but
fiduciary duties.
right. But did he say like an example of like what I would find out from the seller?
No, just that anything that the seller tells you, it is as if you told the client because we have full
Right.
disclosure, right?
Yes.
And so that's what she was saying.
So yeah, and I guess that, yeah, I would say that is true. Like you owe them all those fiduciary duties for that time frame, for sure. But I would say, so I guess to me, I feel like that's less of a risk than doing the showing agreement. I know there's going to
Okay.
be definitely feelings one way or the other with people. And that's why I say I'm not saying we won't end up with one within our company, because it's possible that we have enough agents wanting to use it, but we probably would, as part of doing that, have agents, add to our independent contractor agreement something to the effect that, you understand the risk you're taking by doing that your errors and omissions might not cover it. So anyway, I don't know. We'll see.
That does make sense. Obviously, I only heard her side, so
Yeah.
I liked what you said too about the insurance, because I always point that out.
Yeah, exactly. So anyway, cool. Good questions. Galen, you have one?
I do. Just to follow up on the question before on the addendum, I'm assuming if initially the end date's in 2 weeks or whatever, and then they choose to use you for 6 months, it would just be an addendum required to extend that end date, correct?
Correct. Yep.
Okay. Thank you.
Yep. You're welcome.
And Russ, also, as far as, this, you hear about abandonment where maybe the client feels like you haven't really kept in touch with them, but they're not really looking real aggressively, but they say they have a contract with you for, a month. What do you recommend as far as how often to keep in touch, even if they're not looking? So we're not, being seen as not fulfilling those fiduciary duties.
Yeah, that's a good question. So, I mean, to some extent, my initial answer, my first thought is I think you should be staying in touch with them weekly if you have an agreement with them like this. If you want to make sure that they are not feeling abandoned, but yeah, I mean, I guess that would be my initial thought. But maybe if you had it for a year and they were saying, hey, we're going to take a few months off before we keep looking, then calling weekly. I still think weekly is probably a good idea, of just telling them, hey, I would say you just explain to them, we've got this agreement. I owe you fiduciary duties. I want to make sure you're taken care of. And I would say just come up with some type of an agreement as to, and whether it's in text or an email, of what's your agreement of what that is going to look like if they're taking a break for a while. I hope that makes sense.
Yeah, that's helpful.
Cool. Okay, the next part of this is a section here that you're going to check the box or not check a box saying that the buyer does have a representation agreement with another brokerage for the following properties and they're excluded. So what that means is we're going to have to start making sure to ask buyers when they sign this, have you signed this with anyone else? And if so, was it for specific properties or for specific counties? And then you're going to need to list in here whatever properties. So let's say they had signed in Salt Lake County and now they're wanting to look in Davis County. You would need to check the box saying they do have a representation agreement for the following properties, and then you'd have to just put all Salt Lake County in there. So that way, and the good thing about this is then it's making it clear between us and the buyer. Are we understanding who they have fiduciary duties to for different counties or properties or whatever? So to some extent, it'll be interesting to see how this plays out. If you end up getting with buyers that are like, "Yep, I've got this property and that, I've got 5 agents and 6 properties that we have to exclude from this." So it'll be interesting to see how that plays out. But anyway, that would what this section would be here for. The next piece of this is the brokerage fee. So this is where the bulk of the change has happened within this agreement. And the section 2.1 is talking about their obligation to pay. And so this is where you're going to put in the $295 or $495, $595, $695, whatever you're charging, and whatever percentage you're going to be putting in there, which I would recommend that you put in 3% there or more, meaning put a higher number rather than a lower number. And the reason for that being that is because you cannot get paid more than whatever is in here. So like, for example, we've had agents over the last for years and years, putting in 0 or MLS right here. The idea being we're just going to take whatever's being offered on the MLS. Well, you can't take you can't take more than whatever is put in on this line. And so let's say, for example, that the seller, when you go to show the property, they have something showing on there saying, on the flyer or whatever that says 3% buyer brokerage fee paid by the seller. If you had put 2 or 2.5 in here, then you're going to have to actually go do an addendum to change that. Now, you're going to hear, if you haven't heard already, you're going to hear people saying, if you're going to change that and increase it, you also have to justify why you're increasing it. And so UAR's attorney talked about that, and he said technically that would be true. However, there is case law that happened recently in Utah that says basically it would have to be a dramatic increase. So meaning like you'd have to be going from saying, hey, I'm going to only charge you $500, or maybe it's even less than that. Let's say $100 for a fee, and then doing an addendum saying, okay, now it's going to be 3% of $1 million. So now we're going from $100 up to $30,000 is what the fee is going to be. You could potentially run into an issue with that being like, hey, you got to justify why your fee went from 100 to 30,000. But doing it from 2% or 2.5% to 3%, he's like, that's not significant enough. And the other side of it is the buyer is the one that would have to sign the addendum agreeing to this. And it would have to be the buyer then going back saying that, like, they would have to be the one basically starting this lawsuit. But the problem is if they already signed it agreeing to increase it, it wouldn't make sense for them to try to go back and sue you. So if you do hear people or read things on social media about you can't increase it, just know that is not true. You'll just have to do an addendum. So if you did 2.5 here, and then the buyer, or let's actually say it this way. Let's say you put 3% on here, 295 and 3%. And then when you go to see the house, the seller is offering an incentive and says, we'll pay a 3.5% buyer brokerage fee. Well, great. then you just go back and have that discussion with your seller or your buyer, excuse me, and do an addendum to this and change it to 3.5%, and you're good to go. Okay. So that's the idea of this buyer's obligation to pay the brokerage fee. 2.2 says that if a seller's brokerage or the property owner is compensating the company on a property acquired by the buyer, then the compensation paid to the company by the seller's brokerage and or the property owner shall satisfy buyer's obligation for the brokerage fee shown above, provided that it is equal to the brokerage fee. So, and then this is where it says the company may not accept total compensation from any source that is greater than the brokerage fee. In the event the compensation paid by the seller's brokerage and or the property owner is less than the brokerage fee, the buyer will pay the remaining difference at closing. So that section is just saying, if we get either the brokerage, the seller's brokerage, or the seller to cover this fee for you, as long as it's equal to that, you're good. If it ends up being, hey, you signed it for 3 and they're only offering 2.5, then you're going to have that conversation with your buyer and or have them pay it, and or you do an addendum and change it down to 2.75 or whatever it is that you have agreed to. Okay. And then the last section here, 2.3, just says unless agreed to in writing, it's due as of the recording of the property. If it's a lease, the effective date of the lease, or if it's an option, the date the consideration for the option agreement is paid. So any questions on the brokerage fee section? Okay, good. All right, the next thing that has been added to this one that was not in the previous, and it wasn't in ours or the previous one on the MLS, is under the protection period. They've added this section right here that just says that if within so many months after the termination or expiration of the agreement, they go buy a property that you had shown them, you would be owed a commission. And then they've added this unless the buyer's obligated to pay a brokerage fee on such acquisition to another brokerage based on another broker agreement entered into after the expiration or termination of this agreement. And there were a couple of brokers at this meeting that I was at that was saying, hey, that just doesn't seem like it kind of makes sense on the seller side, but on the buyer side, it doesn't make sense. And basically what the attorney said on that, because ours has not had that for a long time, as an FYI, not had that highlighted section there. And what he said is a judge would look at that and say, you're trying to obligate this buyer to pay you after your agreement has expired and they've gone and used somebody else now, meaning your agreement's already over with and you're going and they've gone now to another agent and going to do this. He basically said the chances of enforcing that are very, very slim. And in fact, he said so slim, I don't think you're going to see it ever happen. So anyway, kind of that's the justification for adding this in, is it just makes it clear for us that, hey, if you don't help them during it and it expires and then they go sign with somebody else, then you're not going to be entitled to that commission. And he said that's really probably what would have happened anyway. So anyway, that's that section. Last thing that we have on here that is changed is this dispute resolution. On this one, you have 2 different options, either shall or may. And so the thing that I would say on this is, as a general rule, from the company's perspective as a principal broker, my preference is that you check the shall box on this, that we go to mediation first before going to court. And Jason and I had talked a little bit even this morning about it. There may come a time that I just check this box and then upload that to .loop so that it's already checked. But just know you have either option, the shall or the may at this point. My preference would be that you do shall on this. Now on the REPC, maybe not. You can either way, whatever the client prefers. But because this contract, so the REPC is between the buyer and the seller. So if the buyer prefers may, then do may. This one is between the brokerage and your buyer. And so because we're now a party to this contract, my preference would be that we say we shall go to mediation first, just because hopefully we can work it out there. It's going to be a lot cheaper than than going to court. So anyway, as you're filling it out, just know my preference would be that you're checking the shall box on this. And like I say, at some point we may just check the box and upload that to dotloop. But even if either way, if you pulled it off the MLS, you've got either option. And my preference would be that you do shall on that. So anyway, those are the main differences. Everything else on this is pretty much the same as what you have been using. So any questions on any of that? Okay.
I have a question.
Yes, go ahead, Lisa.
Where I'm, reviewing these documents, I get a little confused with the two documents asking for payment from the seller. And the one is the agreement between brokerages and the other one is the addendum.
Yep.
Help me understand if we need both. Say, for instance, I've signed a buyer broker 3%. They're offering 2%. And it says on the addendum that you can't have more, or how do you get the other percent for the seller to pay? Excuse me.
Yeah, so that's a good question. So what she's referring to, just make sure everybody knows, is there's two different forms. There's the buyer, the brokerage payment addendum, where you're asking the seller to pay it on behalf of the buyer. And then there's a brokerage compensation agreement that would be between the two brokers. And so let me kind of first preface it by saying this. I believe in the long run, that the broker compensation one, the one that's between the two brokers, I think will be used a little bit at first. And over time, I think we will very, very rarely use it. Now, I could be wrong on that, but I think we will very rarely use that form. I believe what's going to happen the majority of the time is that people are going to use the brokerage payment addendum. And actually, as an FYI on that, if you weren't aware, the Division of Real Estate has submitted to the Attorney General to add that section, the brokerage payment addendum section, right into our REPC. And so I feel like once that is added, even if it wasn't, but I think for sure once that section is added into the REPC, which is possible, they're targeting or hoping to get it back by Wednesday, but the attorney said he thinks it might be 2 or 3 months, or 1 or 2 months. But I think once that's in there, I don't know that we will use the brokerage compensation agreement. So anyway, that's kind of my belief. But let me answer your question now. So the option will be, you call the listing agent and say, is your seller willing to pay the buyer brokerage fee? They say yes, and you say how much. They tell you, then you would fill out that compensation agreement. You would sign it, send it to them to get them to sign it. The seller signs it, and the buyer signs it, and then we now have that agreement, which would put us in a scenario similar to what we currently have on the MLS, where the seller's brokerage is now going to pay it to the buyer's brokerage. So that's one option of doing it. So in the event, though, that they did it at, say, 2%, but you wanted 3%, then you would also throw in that brokerage payment addendum, asking the seller to pay that other 1%, which would be similar to how we've done it now. If on the MLS it said 2%, but you wanted your buyer had agreed to paying you 3%, you would send over that brokerage payment addendum as part of the REPC, have the seller agree to pay that other 1%. So I know it's so hard on these sometimes to work that through in your mind. So did I answer that, or is it still confusing?
Yeah, and my concern is I understand it that way. So it's first get what they're going to offer. If that's not going to satisfy, get it in writing no matter what, and then also use the addendum if there's an additional
Correct.
request for the, to match your buyer broker. Am I understanding that correctly? So
Yep.
we're using both forms basically.
Potentially.
potentially, to
Yeah.
get it in writing first. Because if we just did the addendum saying 1%, I can see where that could be misconstrued that, well, you know, that's all we're paying you if we don't have the other form.
Fine. Yep. Yeah. And that's why I really do think, though, what we're going to see, I think in the beginning, we'll use the one that's between brokers. But I think over time, we're just going to agents are going to figure out who cares, and nobody, meaning, and when I say who cares, meaning I'm going to call listing agents to say how much is your seller willing to pay, and they're going to not call me back, because you know how that never happens, that listing agents don't call you back. So eventually we're just going to go, heck with it, I'm just going to put in that brokerage payment addendum, or like I said, once it's added to the REPSI, it's going to be just the easiest to check the box and put in the dollar amount, and then if the seller has agreed to pay it anyway, it's already going to be factored in. So
And I
Cool.
think too, Russ, as a listing agent, you know, we got to prepare them too to say, you know, maybe in figuring out your numbers, you know, maybe we do a net sheet together or whatever, but be prepared for, you know, buyers that can't pay that extra 1% sometimes.
Correct. Yep. The other thing I would add to that, and we're going to talk more about this on Wednesday. So as a reminder, Jason and I will be doing base camp on Wednesday, and we're going to talk about some language and stuff to use. And so I'll give you a little bit of a commercial for that. But one of the things I think we want to, at least for the next 6 months, maybe a year, we're going to need to do is when you sit down and do a CMA and go through that CMA with the seller, if they're not wanting to pay a 3% or whatever a percentage, I probably shouldn't say 3, but if they're not willing to pay the buyer agent commission, we need to point out to them the comparables we're giving to them right now included that. So if you're not going to do that from your CMA, we automatically need to deduct 2 or 3% from the price that they're thinking that they were going to get, because that was included before. And I think that'll help sellers to see, oh, okay, well, so really it kind of comes out in the wash either way. Either I reduce my price by 3% when I list it, or leave it at 3%. And for me, I would say, yeah, let's come to a price with the seller and then potentially just increase it to 3% if you need to say we're going to cover it. So yeah, for sure, this is all going to be future pacing the seller to say most buyers are going to come in expecting you to pay, and maybe not even expecting is the right word. It might be needing you to pay that because they can't buy a house without it. So yeah, a lot of future pacing for sure.
I have a question.
Sure.
If we already have a buyer broker agreement with a client and they're under contract, do we need to do anything to change the current buyer broker agreement we have?
So there is the addendum to that, but I don't feel like we need to do anything to change those. We do want to start using this new one right away, but I don't see anything in ours current one that would be an issue to that we would need to do that addendum. It other than it does, using that addendum that the UAR created for that does give you that opportunity to sit down and really just explain to your client and have the conversation. So probably not a bad idea to do it just so that you can have the conversation, because to some extent the conversation with your buyer needs to be, hey, you know, what do you want to do? How do you want to handle this if I call and ask and they say no, they won't pay it, or you know, some of that. So I don't think you have to, I guess is what I'm saying.
I'm saying we're already under contract and the sellers have already agreed.
Oh yeah, sorry. Yes, for sure. Under contract, don't change anything.
Okay. And then
other than the only thing is, and I sent this out as an email, but just in case people missed it, if you are under contract and you're representing a buyer, print off a copy of the MLS showing the BAC or BBC, because if for some reason there becomes a dispute over it, it's not like you can go back to the MLS. So we need that printed off so that you can.
And you can just put that in dot loop, right?
Yep. Hopefully it's already in dot loop, but if not, put one in dot loop to make sure.
And then I was just wondering, and I don't know if I missed it, if I can get the verbiage to do the addendum to the listing agreement, letting the sellers know that the compensation will no longer be on the MLS.
Yep. Yeah, I
If
can.
we could just get that verbiage.
Yeah, I'll send it to you.
Okay, thank you.
I don't remember how I said it off the top of my head right now, but I can send it to you. Cool. Any other questions? All right. Well, hey, exciting times ahead. It's going to be fun. Jason and I are excited for all the questions, and I know right now I'm going to be preaching to the choir, so I get that. But I've already had many people come in and be like, "Hey, I know you've been doing trainings on this, but can you explain to me like what's really going on?" So I appreciate, love that you guys, Jason does too. I know that you guys take the time to jump on and get educated on it, because our concern is starting next week, there's going to be a line at our doors going, okay, I know you've already been doing trainings, but I missed them. Can you tell me what's going on now? And that's already happened to me today, actually, even. So anyway, so thank you for taking the time to join and be on there. And we'll send this out as a video. So thank you to those that end up watching it as well. And if we can help, let us know.
Thank you.
You're welcome.